Hi everyone. Today we have with us team NLU Jodhpur, comprising of Aabhas Chaturvedi, Zoya Fazar, and Paavni Kaur Mago, who recently emerged as the winners of the very prestigious NLIU Justice R.K. Tankha Memorial International Arbitration Moot. I'd like to mention all three of them are second year rights, by the way. Firstly, many big congratulations for your success in the prestigious competition. Before we begin talking about your journey, I request you to please introduce yourselves to the audience.
Hi, thank you so much for your wishes. My name is Paavni Kaur and I am a semester 4 second year law student at NLU Jodhpur.
Thanks a lot for inviting us. I'm Aabhas Chaturvedi, and I am a UG Semester 4 student pursuing BLLB honors from NLU Jodhpur.
Hi, my name is Zoya Fazar. I'm a fourth semester student at National Law University, Jodhpur, pursuing DLLB honors.
Great. To start off the discussion, please tell us about the structure of this competition and about your team composition.
Yes, so this competition basically is an international competition wherein people from all around the world, many from all around all countries come participate. However, it's physically held in India, at NLIU Bhopal. We had 60 plus teams participating in this edition. So for the first time, this edition had a memo qualifiers round. Basically, we submit memorials from both the sides. And after that, we have a memo qualifier round wherein 38 teams got qualified, and all the 38 teams were invited for oral pleadings at NLIU Bhopal, and we were one of them. So there we had quarterfinals out, then semifinals out, and finals out. Basically, out of 38 teams, 8 teams get qualified for quarters. Now, the format of the moot competition is you are allowed to have maximum of 4 members team. However, our college, NLU Jodhpur, only allows for a 3-member team. So we were 3 members, 2 speakers, and 1 researcher. I was the researcher, and Aabhas and Paavni Kaur were speakers for this competition.
Thank you, Zoya. Preparing for a moot must definitely be a long journey. Everybody knows that. Considering the complexity international arbitration as a subject in itself carries. Could you break down your preparation journey for us in terms of your research for the memorial and the presentation for the rounds, so to say?
So, we got this competition allocated before the proposition for this competition was released. As soon as the proposition was released, we read the proposition carefully, and then we sat together, delineated the issues. We divided the issues amongst ourselves, taking into consideration who will be the speakers and then what issues they should research upon. So I took the arbitration issue. Paavni took CISD, 2 issues for CISD, and Aabhas took the artificial intelligence issue. This was the first step for our preparation, and then obviously we basically approached our coaches, our seniors, like our college seniors, and many external people as well, and they provided us with pre-readings as well. So before the proposition was out, we made sure that we basically read the basics of the law, the basics of arbitration, and I remember we read Gary Vaughan Wally book for commercial arbitration, and then we went through all the process.
Competition essentially is based on international arbitration, right? However, it is called mini-viz because it deals with both issues of commercial transactions in international sale of goods as well as international arbitration. Now, between these two major themes, there was this one issue which was very factual specific, which I took upon. And the issue was relating to an artificial intelligence system, whether or not it can be considered as an expert system or not under law. It was a very interesting moot question, with there being no precedents available for the same or no judgments available on the same. It was essentially a futuristic and a hypothetical moot question. So, with there being a scarcity of resources to peruse, I essentially relied on scientific journals. I essentially tried to understand how an artificial intelligence system works, and then I tried to compare it with the threshold as to in various global jurisdictions, how and why and when an entity can be considered as an expert, when can its opinion be considered as an expert opinion, etc. And then I tried to fit in the characteristics of an AI system or eliminate the characteristics of an AI system from these thresholds. So essentially, the way I approached was to firstly frame a fixed threshold, and then trying to apply the scientific knowledge that I tried to gain with regards to artificial intelligence in those thresholds. It was a very objective process for me.
So I dealt with the merits part of the entire moot, essentially CISG, which is basically the United Nations Contracts on International Sale of Goods. Now, this essentially is a very international subject matter in itself, because while everything was essentially India-centric with regards to law, this was international sphere, because CISG is something which, like Aabhas stated, they deal in viz. So for my specific subject area, very honestly, it was completely reading intensive, because applying specific articles in that part of the subject matter, it is very important that you know the law very well. So I think one thing that I faced issues in the beginning, but I got very comfortable, and what worked out for me ahead was that I was super clear with regards to what law I was arguing. So that could also be something which anyone who's in future considering this mood possibly should know. So that was one thing that I think helped me throughout this entire journey.
As and when you progress to the subsequent rounds, your approach also changes according to the feedbacks that you get from your peers. Your mentors so have already given their feedback, but according to the judges' feedback also. So, how did your approach to the preparation for the subsequent rounds change from the one that you went to the competition with?
So for me, when we are trying to practice for oral rounds, once our memorials got qualified in the memorial qualifier round, I was advised on my pace. I was advised on my hand gestures because inherently I'm an overly excited and aggressive speaker. So I was advised on my hand gestures because essentially when we are doing a moot, an arbitration moot, we are generally advised to assist the court as a friend. We are essentially arguing before a tribunal, not a court, not a formal court. So the members who are sitting and who are judging us essentially are our colleagues. Even in the professional sphere, we were advised that whenever you are going to take up arbitrations, the persons who would judge you, you might judge them the other day. So essentially, they are colleagues. It should be informal and it should be assistive in a process. Over here, the council is not fighting for a case, but fighting to assist the tribunal essentially. So I had to change and learn how to change to be more calm, more composed when I'm speaking, trying to talk to a colleague, trying to come up with analogies in my transcript, not follow a very fixed and a firm transcript. And most importantly, in any arbitration mood, the one skill that I was asked to focus a lot on by my judges was to be witty enough to answer each and every question on the spot. Because in this, our proposition, along with the clarifications, went up till 46 to 47 pages. So memorizing each and every contour and being very comfortable with the whole factual matrix came in very clutch at that point of time.
And just to add that he says about the oral rounds, I clearly remember that when I was giving one of my oral rounds, at the end of it, it started off with our coaches only. So they clearly said this one thing to me, that when you're arguing in front of an arbitral tribunal, you need to be clear and you need to basically explain it to them. So I remember when I was giving my final round as well, I was essentially explaining it to the judges what exactly it is that I'm saying, more than just arguing. So I think that is a differentiating factor which comes with arbitration centric moods, because when you're arguing in front of an arbitral tribunal, you are not just reading the law to them, you're explaining it to them without the legal technical words, in analogies, with examples, which I clearly remember I did in my final round, just so that I could put forward my point as clearly as possible. And I think that is also a differentiating factor when it comes to normal litigation law rooms that is happening. So I think that's something that everybody should be mindful of.
Can you?
So just to add one thing,
Yes.
so wherever they were giving oral rounds to our coaches and many people, external people as well, I was with them, I was sitting with them. So I made sure that I relearned things that I read and I listened to them. As Pavni said, they were trying to explain. So if I got what they said, then they're like successful in what they're doing. But maybe they're using any analogy and that is not landing well, that would be like something we would ask them as feedback to change or work upon. So that was the whole process we undertook before the actual oral rounds.
That is a very efficient way, actually, right? Can you share any memorable courtroom moments or highlights from your experience in the competition?
It was a very topsy-turvy ride. We essentially argued 5 times before the tribunal, two preliminary rounds followed by quarters, semis, and finals. And out of those five, the two preliminary rounds and the quarterfinals specifically were very challenging. Um, so with regards to our second, in our first preliminary round, Paavni would share her side of the experience. But for me, um, due to a feedback by one of my professors, I kind of changed my structure at the very last moment. So I was not very comfortable with that. And that got stuck out as a sore thumb to the judge, because then the judge said that my structure was a bit problematic. The second preliminary rounds was very painful as a speaker. The judge picked on me and they essentially tried to test my composure and my tenacity as to whether or not I would give in and concede with my argument to the judge, even if the judge is explicitly saying that we are not convinced with the arguments, or I stay and provide alternative views to explain them, which is one major learning that I took away, that even if uh, even if the judge is not getting convinced with the arguments, you do not have to really concede your arguments, but maybe be ready with an alternative view to explain it to them. And the quarterfinal rounds were the most challenging. I remember we faced Nirma and INLE Nirma, and they were a very solid team. And at the end of the day, it came down to bare margin. And the round actually spanned out till 2.5 hours. So that was a very interesting round. Maybe Bhavni would add on to that.
I think I was just recounting that moment only. Our quarterfinal went on for somewhere around 2.5 or probably 3 hours, and that is something which usually does not happen. That is only happening when the judges are really wanting to listen to what you're trying to say, and they're giving you opportunities to tell what exactly you're wanting to explain it to them. So what happened was that since they follow a respondent claimant respondent procedure in speaking, so I was the last speaker in that round, and I was super shaky with regards to my arguments because the bench was, I don't know if I could convince them. Plus, they were already sitting there for the last 2.5 hours, and it was thrilling, if to say the least. But still, I remember going there, and Aabhas used to send me chits, and the only memorable experience is that both my teammates used to send me chits saying, "Oh, you're doing very good. Oh, just do this. Oh, just do that." Normally, people are giving suggestions. My teammates just used to positively reinforce me, and that is one experience and one memorable moment that I don't think I can ever forget from this moot.
Beyond legal arguments, what non-traditional skills or approaches do you believe were crucial to your success in this competition?
I think when it comes to something which is non-traditional, or perhaps something which is simply to say beyond the legal acumen, I think it's about understanding the proposition as a logical person. Now what happens is that people personally believe that when it's a moot competition, they need to delve into the legal aspects and the legal knowledge of the entire proposition to the very core. But sometimes what the judge is actually wanting from you in the particular moot round is to give a very logical answer. To just provide a small example about it, in my final round itself, I was very, strongly arguing about my CISG Article 3, blah, blah, blah. And the judge simply asked me a question that, okay, if you're saying this, then is this happening? And they merely want me to say a yes or no answer. Now, if I know my law well and if I know the proposition well, then as a logical man and in a logical perspective, I can answer them and that will satisfy them. Which a lot of times, and in a lot of moot court competitions, personally as well, in my previous competitions, I was not clear with. So I think that, reasonable man's perspective that we say in our legal terminology, that logical perspective is something which goes beyond all the legal reasoning that can come with. So I think that is something everybody should take with them in any moot court competition.
To add on to that, when it came to my issue, I basically tackled the procedural part. I tackled Zoya's issue and the issue on artificial intelligence when I was arguing. So the most effective and the most impactful answers, the most convincing answers, were the one that were not law-based, were the one that were majorly focusing on the factual matrix, majorly focusing on the commercial aspect of how our clients and the parties that we are representing are commercially affected by the factual matrix and by the laws at hand. So when we are trying to approach a moot court, we should not approach a moot court as to the basis uh, of a numerical competition as to how many citations do we have or how many authorities do we have as opposed to the other side. At the end of the day, it boils down to the application of those authorities with regards to the factual matrix, and the factual matrix and commercial and logical aspects take the forum. Further, I realize one aspect that no side is weak and no question is impossible to crack. Essentially, each and every law question or each and every moot question would have its own way to be approached. Some might have readily available precedents which you can analyze or distinguish. In some manners, you may have to create your own logic and you may have to create your own arguments from scratch. So, regardless, we shouldn't get bogged down by the same, because with the very rapidly evolving field of technology, law, and finance, um, I feel like there would be many more such moot questions which I hope that I would get an opportunity to tackle, which might not have such precedents. And further, I wouldn't get bogged down by the same.
Talking about a non-legal scale, I think you have to be a tolerant person. You are working with your teammates for maybe 6 months, and all of us are different. All of us had different work style. Then, so be a tolerant person, tolerate everyone, and that's it. Like, work, have a good team spirit.
Okay, so in one line, what advice would each one of you give to law students who are aspiring to participate in such competition?
I think that's a very tough question because suggestions and recommendations are something that I personally struggle with a lot. But
Okay, you
Aabhas,
can
why
tell
don't you?
one learning in one line you have to tell it. If it's not an advice, you can tell the learning that you took back home.
I mean, I'm not in a very good position to dictate what suggestions one should follow, but I just feel that regardless of whether you're doing a moot, an ADR competition, or anything in law school, the one learning that I derived from this moot court competition was that to to stay firm, to stay tenacious, and to stay persistent. If we give up and we concede, that's the end of our argument, that's the end of our case. However, if we stay calm, if we stay composed, and if we try to think well on the spot, the courts or the tribunal or the judges would be assistive enough to allow you and accommodate you for some space to think, for some time to think, and to come up with creative arguments. Never shut down creativity, never be stuck to a particular transcript or a particular way of arguing that you want to pursue. Always be flexible and always be curious.
I think I would say that first of all, keep reading because that's a very mood centric possibly suggestion, but it's in general for law school and even before law school. So keep reading first of all, and keep getting to know law as well as you can. And secondly, be confident. So a lot of times, when I was standing on the podium, I possibly did not answer it the question which I thought I should in a way that I should. So I don't think people should, get frightened or they should, scare themselves away from answering the question in a way that they want to. So these two suggestions would be something which come from my experience. So just say it and be confident when you're there on stage.
I would say communication. So what I believe is our team had a good communication team. And so whenever you're doing a moot, speak up. You're having any doubt, speak up, ask your doubts, pester your coaches. That will help you gain clarity. That's it. That is the most important part, I think.
All right, team. Thank you very much for being here. Your insights were incredibly valuable, and I'm certain that our audience will benefit greatly from the wisdom that you've shared. Thank you once again for your time, expertise, and generosity in sharing your knowledge. I, on behalf of ILCC, wish you all the very best for your journey ahead. Thank you.